Milady, we were speaking about the economic crisis that the evidence shows the city is facing because of COVID. And one of the things that economic crisis, how it affects people, particularly poor people, indigenous people, is the loss of jobs, the higher rates of unemployment. And this development is a significant development. It's going to result in over 5,000 jobs. It's currently providing jobs to 5,000 people. And those are the direct employment opportunities. Indirect employment opportunities are 19,000 jobs. The court, we submit, can't disregard that and say that's not an important consideration. 19,000 jobs which will be lost in a context of a city facing an employment crisis. That crisis is referred to in the affidavits. It's not disputed. It's a employment crisis which is at historic levels. There's never been such a high unemployment rate. It's described as alarming and record levels. The rate for Cape Town is 30%. That's the formal employment rate. That excludes people who've given up looking for jobs. And it's resulted in profound poverty, or it's exacerbated a high level of poverty which already exists. And I'm not going to take your ladyship to the references. Your ladyship will be familiar with the economic problems and the crisis that the country and the city is facing. If I may refer to the also undisputed, the investment benefits of the development, the construction will provide an investment injection of 4.5 billion rand. And that's the direct investment of the construction work, and that will result in an increase in economic output for the city of 8.5 billion rand. Those are staggering figures, and if I may put them into context again to show how that relates to the construction activity in the city over the last period, and that's dealt with at the record at volume 5. Here's Mr. Kraling's affidavit, in which he says that from 2018 to 2021, Cape Town had a 50% decline in the number of big investments. So even before COVID, there was from 2018 to 2021, and one sees the graph there, the blue bars are the number of big investments. It's declined from 20 to 10, 50% decline. The red line shows the monetary value of that, and that's declined by 56%, from 2.3 billion to 1 billion. So there's this massive decline in the construction industry, and one compares that to the economic value of this project. Your ladyship will recall that the value is 4.5 billion. So if your ladyship imagines this decline from 2.5 to 1 billion, and this project alone will add 4.5 billion. It's a significant investment to the construction industry. And the construction industry is a major part of the economy, providing jobs and alleviating poverty. Transport, your ladyship is familiar with the road developments, Berkeley Road, there's going to be a bridge built. The value of that is 73 million. Residential, 31,000 square meters of high-quality residential accommodation, of which 20% will be affordable housing. This is one of the first developments in Cape Town in which the developer has said that integral to the residential component will be affordable housing. And it's the first approval, which I know of, in which the planning authorities have made that a condition of approval. So it's not just a promise, again, it's a legally enforceable condition. It must be provided. That's integrated affordable housing of 1 out of 5 square meters, 1 out of 5 units. All of that will be lost. That's the harm that will result from an interdict. And we, under the branch which said that an interdict will block these benefits, there's there's the evidence of the mayor, which is undisputed. I'm not going to take your ladyship there, but because we've already debated this, it's the point that a delay in development can kill a development. And it's particularly acute. This development's been coming on for 6 years. When the first authorization, first notice of intention to develop was given, there have been a series of considerations by various authorities. There's the heritage considerations, environmental approval, planning approval, each with various challenges. There was a review case and an appeal in relation to the heritage matters. There was an appeal in relation to the environmental authorization. And the planning approval also had an appeal. Multiple considerations over a long period of time.
And the water issue as well.
And the water issue doesn't seem to be an issue because it was applied for and was granted,
reversed,
and the applicants have never said that there's a problem with the water license. It seemed to just be a tactic to prevent the development. But it was said in papers that it seemed to be an application without any merit, and they haven't suggested that. No, actually they've got good grounds. In fact, we know they've got no good grounds because if they did have, it would be a subject of this interdict proceeding. They don't even raise it. So it's really about heritage approvals, which are subsumed in the environmental approval, the environmental authorization, planning approval. So what happens with the development, explained in the affidavits, is as the development progresses, particularly a big one, it gathers momentum, which requires additional financing. It's very expensive getting to the stage when one implements. One doesn't simply hire the construction companies and start. There's a whole lot of professional work done with architects and engineers and setting up all the financial arrangements. And by the time it gets to planning approval, that's very far down the road, and there's massive holding costs. So an interdict at that stage then starts a wastage of costs, and that an interdict which then has the financial consequence. And the city has experience of this, which it said in the affidavits, is that an interdict can itself, even if the review fails, the interdict itself can kill the development. And we have the additional consequence here that the anchor tenant is not tolerant of any delay. The city has a particular concern about an interdict being granted, and there's been a question about, well, what is the city doing here? It's been suggested that the city is siding with the developer. And that's not true. That the city is is here giving effect to its constitutional duties. And it has duties under the Constitution, firstly, to promote sustainable development. There's a right under Section 24 to sustainable development. And the city has a duty under Section 7 of the Constitution, not only to respect that and to protect that right, but to promote it. That requires positive steps. And this project is an excellent example of sustainable development. It achieves development in a way that actually helps heritage and the environment. And the city also has duties under the Constitution to promote development, economic development. So those are in sections 1521 and 153A. The references are on the mind map. And so the city must promote development for the economy of the city, for jobs, and for the benefit of all the residents of Cape Town. And happily, there's no trade-off between those two considerations. So if one looks at the mind map, it's quite useful to look at this graphically because that's the balance of convenience exercise that the leadership will be is considering. So there's one branch which says prejudice if the interdict is granted. And then there's the bottom graph on the map which says prejudice if the interdict is refused. And without reading the words on the map, your leadership will see all of the considerations which we've been discussing on prejudice if the interdict is granted. They're considerable, overwhelming, both in number of them and weight in them. And then the other side of the scale is what will happen if the interdict is refused. What's the prejudice? What's the harm? And there's not much there. But let's deal with what is there. The first thing to remind your ladyship of is the frustration that the court had on the first day of the hearing, asking the applicants, what do you want with the site? there was no answer, because the applicants aren't able to give a feasible alternative to the development as a way of protecting heritage. The throwaway, on-the-spot suggestion was some sort of expropriation. Well, that's not on the papers. What is on the papers is the city's answer to the question of an urban park, which has been mooted for a long time, and that's dealt with in Volume 4. The applicants contend, this is the mayor speaking, the applicants contend that this property should be converted to an urban park. However, the applicants offer no feasible route to achieving this. In 2003, the city accepted that an urban park was a development possibility for the site. However, over the past 18 years, such a development has proved to be a pipe dream. It is unfeasible because there are no funders for an urban park. There are no workable development plans. That evidence is undisputed. In reply, the applicants say that that just because an urban park is not feasible now doesn't mean it won't be feasible in the future. Well, that doesn't show that there's any road to feasibility. It's just a notional, well, maybe it'll be feasible at some point, but we've waited 18 years, and the city says it was part of this vision of having an urban park, and it's not going to happen. Applicants do not explain how development will harm heritage. There's simply no evidence of that. The court is left with the conclusion that the evidence would not, that interdict would not protect heritage. And I've dealt with the developer proceeding at its own risk. So, looking at the practical consequences of an interdict, Your Ladyship, that scale analogy is going to weigh in, excuse the pun, in Your Ladyship's mind. On the one hand, what are the things that sit on the one side of the scale? What are the things that sit on the other side of the scale? And the image is a very disparate balance. There is no balance. There's nothing up here. It's just a pipe dream. And on this side, we've got the need to protect heritage, a way of protecting heritage, a way of advancing jobs, a way of providing economic recovery, all of which is going to be lost if an interdict is granted. So that provides an overwhelming reason to refuse an interdict, both if one looks at it from a balance of convenience and prima facie right, because the applicants on the outer test haven't shown that the development will irreparably harm heritage, will not harm the cultural rights. And even, in answer to Your Ladyship's question, even if it's not the test under outer, but even if what Your Ladyship is mindful of what consequences an interdict would have for the review grant, given that the developers are proceeding at their own risk, there's no prejudice to the applicants in arguing for whatever remedial relief is appropriate. So that takes us to the second page of the mind map, which deals with the prima facie right, that the test under outer is that that's the only question of prima facie right is a question of whether there'll be irreparable harm to heritage, and we've dealt with that. The second branch to it is a branch which we submit is not relevant, but we deal with it simply because it's such a strong part of it's the entire case argued by the applicants, and that is the right to review. It's put in inverted commas because we submit it's insufficient, if it's either irrelevant or insufficient. There are 3 points in relation to this. First is the law and pleadings. The second is the review case against the city. And then the third question is the issue of participation, which Your Ladyship is concerned about. So if I may start with the law, just to again set the legal framework for how the court will approach this. And may I refer to the bundle of authorities provided by the city. And this is the Supreme Court of Appeal case in Essa. In this case, the court was dealing with a case made out in reply by the applicants in that case. And Judge Pascoe says these challenges, so it's halfway through paragraph 60, these challenges were not raised in the founding affidavit, but only in the replying affidavit, with the result that the respondents had no opportunity to answer them. And this relates, we'll carry on with the quote, but just to interject at this point, there's the question of what case has been made out against the city, and I'll take your ladyship through the affidavits and show that there was an attempt to make out a case in the founding affidavit which then collapsed, and then an attempt to make out a case in reply, and that is, the Essa case says that's not permissible. And the reasoning for that is something which we'll deal with in the next paragraph of the judgment. But in relation to participation, which we'll come to, is that participation wasn't even made out in reply. So this is a considerable understatement of the position in this case. So even if it was made out in reply, that's impermissible, and that's what the court's dealing with here, where it says why you can't make out a case in reply. The court says, I have my doubts about the correctness of these arguments, but I don't intend to traverse the issues. The challenges fall for a more fundamental reason. In motion proceedings, applicants are required to make out their case in their founding affidavit and may not make out a case in reply. These challenges were not raised in the founding affidavit, but only in the replying affidavit, with the result that the respondents had no opportunities to answer them. And then the reasoning is important because it goes to this court's fundamental role in ensuring equity of proceedings, equity in the process of proceedings before it. And Judge Pascoe says this does not stem from an overly technical approach to pleading, but concerns fundamental fairness. It has been considered and applied by the Constitutional Court recently in the Khaleka Kansa case. The appellant, in that case, sought to introduce a new cause of action in reply. Cameron J. observed that the High Court had rightly rejected this evidence, as must we. He explained the reason for doing so as follows. This is not to stump Khaleka Kansa on technical points. It is to insist that a litigant should stick to the case it has set out in its challenge, and that it does not ambush its opponent in reply with a new case and new evidence entirely. So the applicants may not make out a case in reply, and what they certainly may not do is rely on argument on a case that's neither made out in their founding papers and replying papers. We'll get to that with relation to participation. Firstly, the review case against the city in the papers and in oral argument. There are two features of the case against the city. The first is that it has been a shifting case, and the second is that the case has collapsed. The shifting nature of the case is set out in this table in the mind map. So that sets out the case made out in the founding affidavit, the replying affidavit, and the oral argument. The references are in the record. I'm not going to take your ladyship there. This is a summary of the applicant's case. In the founding affidavit, there were three grounds for review of the city decision. The first was the pending decision to grade the site. That fell away because actually there was no pending decision. It was merely a request. It's not been persisted with. The second was a suggestion that the provisional protection order was still in operation. Well, the applicants now accept. In fact, in oral argument, my learned friend said the provisional protection order has lapsed. That's correct in law. It has lapsed. And the third attack was deviation from policy. In reply, the first two grounds fall away, and what we then have is a challenge that there's a flood risk, and that wasn't properly considered, biodiversity challenge, and insufficient weight given to objections by the city's department. There was an appeal by one of the departments in the city, and the applicant said that the mayor should have given more weight to those considerations. Your ladyship will know that the weight given by a decision maker to a consideration is not a a factor in a review, so that doesn't provide a review ground. And the flood risk and biodiversity are matters which are raised in reply, which it would be unfair for the city to consider. And that new material obviously falls out to be struck. It falls to be struck out, and there's an application to that effect. What we left with, and may I just add that what happened after the founding papers is that the city filed answering papers which comprehensively dealt with the case made out against it, including a reference to the mayor's appeal decision. Your ladyship would have seen from that it's a decision which is 146 pages long, single line spacing, concisely written, detailing the consideration of all of the issues that the applicants raised, all of their concerns and objections, and a thorough engagement with all of those issues. The applicants brought their case against the city without having read the decision against which they were seeking to review. Their attack was a recycling of the complaints about the municipal planning decision, and there was a 1 or 2 lines in the founding affidavit saying the same problems apply to the mayor's decision. Well, that's wrong, because the mayor made a very different decision. It's a 146-page decision. A very substantial consideration, engagement with issues, a whole new set of conditions. The applicants didn't read that. And then once they did read it in the replying affidavit, they couldn't come up with a criticism of it. There's no review grounds based on a very, and correctly so, because it was a very thorough decision. So what one sees is oral argument in which the only complaint is, the only one that's actually mentioned is reliance, the reliance that was, there's a complaint that the mayor relied on the Atmas report. And that's dealt with if I may ask the court to go to the note on oral argument at page 63. It's quite an extraordinary statement of the applicant's case against the city. May I refer first to the paragraph 4, on page 3, where there's a summary of the oral argument, and the applicants say that the applicant has established a prima facie right against the provincial authorities. So there's an extraordinary sentence that says, it is obvious from the papers and heads of argument that the applicants are still in the process of refining their review grounds in respect to the municipal planning decisions. It's a rather quaint, shy way of saying there is no case. These matters will receive considerable attention in the affidavits to be filed in terms of Rule 53.4. So the criticism that one finds here, not even doesn't pretend to be a review ground, in the next paragraph is that in the mayor's affidavit is that there was, what they say is very extensive reliance on the Atmas report. And then the submission 165, that the report is, that's the Atmas report, is unconstitutional, unlawful, unreliable, based on racist archive material and racist conclusions, and is deeply flawed in further respects. And they say that too will form part of their affidavits coming in due course. So we need to just deal with the evidence on the Atmas report and how the mayor dealt with it. And in that regard, may I refer to volume 2, page 577 of the record. And I'm just going to, when I'm reading, I'm going to substitute the names for the first applicant. So it's referred to as the GTKC, sorry, it's the second applicant. So the mayor says the second applicant complains that the Atmas report, that's the First Nations, RC First Nations report, attempts to write out of history the current Goya. Further, and then there's a reference to reliance at the end of that paragraph on colonialist and criminal Jan van Riebeck. And the mayor in the subparagraphs respond to that complaint that the Atmas report attempts to write out of history the Goring High Corner. In subparagraph 185.2, the mayor says that the second applicant has been fully able to participate in these proceedings, to put forward its own narrative, and it has done so. The city has considered the second applicant's submissions, so there's no question of its history being ignored or irrelevant, or informants being excluded in the assessment of the development proposal. May I ask your ladyship to make a note next to that? And that is that in this report, and we did the exercise last night and checked, there are 40 references to the submissions of the second applicant in this report. That's how extensively the mayor engaged with what the second applicant said, and what its complaints and concerns were. Each one of them were catalogued, articulated in a way which was a fair reflection of the concerns and responded to, including this one, that the second applicant was by no means excluded. In the next paragraph, 186, the mayor says that the second applicant argues that the Atmas report set out to diminish and smear the leadership of the Goring High Corner Council for purposes that we believe are motivated by the fact that the Goring High Corner unashamedly rejects the proposal. That's a quote from the second applicant's submissions. Rather than an inclusionary instrument, the second applicant contends that the Atmas report excludes and attempts to humiliate those who see things differently. So the way the mayor dealt with that is he said in sub 2, I acknowledge that the report contains allegations against certain persons that for purposes of the bylaw are unnecessary and irrelevant. I have accordingly disregarded those comments. The remarks about the second applicant do not detract from the other valuable contents that the Atmas report presents. So the mayor says he didn't have regard to the offensive statements, the Jan van Riebeck diary statements, so that they played no role in his decision-making. He said, yes, there's this part of the report that is offensive, that's not part of the decision-making process. There are other aspects in the Atmas report which are relevant. Would have been a reviewable irregularity for the mayor to say, there's a bad part of the report, therefore I'm going to ignore the entire report. What he did is the proper thing. He said, I'm going to ignore the bad part, and I'm going to consider the part that is relevant and material to the decision-making process. So that deals with the only complaint, only criticism, it's not a review ground, only criticism of the city's decisions. So there are no review grounds against the city. The debate in this case up to now about Section 38 is something that only has relevance to the decision made by the province. There's no duty on the city to do anything under Section 38 of the Heritage Act. And the applicants don't suggest that the city's decisions can in any way be impugned in respect of their complaints about Section 38. So that takes us to the consultation issue, my lady. And there are 2 points we make in relation to this. The first is that this issue is not pleaded. And we're going to go into detail to show you why it's not pleaded, because it's not just something that we raise as a technical point. We rely on the authority by the SCA and Essa and by the Constitutional Court to the same effect that this is a matter which affects the fundamental fairness of the case before your ladyship. So under the branch of the mind map which says that the case is not pleaded, we refer to the affidavits. And the point we make is important. The affidavits do not claim exclusion. There is not one iota of evidence. There's no suggestion anybody was excluded at any stage in any decision-making process. There's no allegation in the affidavits that a complaint about participation is a review ground.
Sorry, I just missed the last part. No complaint.
There's no
of?
complaint or there's no allegation or suggestion in the affidavits that there is a review ground relating to participation. And it's a point I was going to make earlier, but let me make it now, that in administrative law, a lack of participation is the first point that an applicant will raise. Your ladyship will know that it's the easiest thing to prove. I wasn't given a hearing, I didn't get notice, I was excluded, or something like that, is a complaint that can be easily established. And the law is very clear that where there's a duty to consult, failure to consult is a reviewable irregularity. It's a very easy basis for a review court to set aside the decision.
And there's no such allegation?
There's no such complaint. There's not even a suggestion that there might be a complaint in that regard. What we do know from the history of the litigation is that the applicants are searching everywhere in the process for something to attack the decisions. They've been involved in this process for 6 years at every step of the way. They have brought whatever complaints they could to the decision makers. They even attacked the water license when there was no reason to do so. They come to the court in their founding papers and they say, these are our review grounds. They get the answers, including more evidence in the annexures. In reply, they add more review grounds, impermissibly. But among those more review grounds in the reply, one doesn't find a complaint about lack of participation. If it had been a problem, it would be there. If the applicants had a problem with participation, they would have said so, obviously. What happened in this case is that the applicants presented their founding papers, the answer, the replying papers, no complaint about participation. They filed their heads of argument, no complaint about participation. The respondents we filed our heads of argument, we dealt with all the issues, and then the amicus comes along and says there's submissions which it wants to make on international law about participation, only on the assumption that there might be a problem with participation, a speculative set of submissions. There's no allegation by the amicus that there was a breach of participation. And so the amicus's submissions only have relevance if there was a failure to participate. And Province, in its answer to that, says, I think it was the developer as well, says the amicus can't plead a lack of participation, can't plead a new cause of action. And so the applicants then grasp onto this point and say, well, in their oral argument, we're going to raise participation. Never raised before. Presented in 101 pages on the day of the hearing. And, milady, what is that if not an ambush, which Judge Cameron says can't happen?